Good afternoon, everybody. We're going to go ahead and get started now, and we really appreciate your joining us today and hope that you're going to learn a lot. We always try to provide a lot of benefit to our clients, and we feel like this is a really important topic and greatly appreciate your joining us. So welcome, everybody, again. My name is Barbara Jennings, and I am with Towne Benefits. I've been here for just about 13 years now, and I am an HR consultant. And what that means as a practical matter is that I'm not a part of the town HR department. What I do is I work with a lot of our clients when they have HR needs and questions, and Corbin Granger and I work together as the HR and compliance team, and we get the privilege of dealing with clients on a regular basis. And so that's what we do. And part of that is providing education and webinars. Now, I spent my career in HR management, I think about 33 years, and um, I really enjoyed it because I feel like it's a helping profession, and it also has given me a lot of information and a lot of just worthy stuff to pass along to people. So now, a little housekeeping. Remember that I am not a lawyer, and that our presentations are not legal advice or tax advice, and you're going to see a disclaimer pop up in a second. And if you have questions, feel free to put a question in the chat box or a question in the question box. Not sure how much time we'll have today, but I'm going to do my best to answer what comes in. And then what I do afterward would be, because it does log the questions, I do try to answer those, and I send the slides to all of our participants, and I also try to answer the questions and send those along with the slides. So that usually takes me a couple of days, but that's what the plan is. All right. Hey, there's that promised disclaimer. So the information here is subject to change. We have to keep that in mind because these laws are out there now and they're being scrutinized, and we're going to get clarity and clarification on, and further guidance on how to administer the laws, what they mean, and that sort of thing. So be aware of that I'm giving you the best information I have today, and that this is going to be subject to change. And now, once we get through this presentation, you'll have a lot more awareness of this topic. And so, keep your eyes and ears open, and that way you can be as informed as possible. Now, and again, this is not legal or tax advice. So really, if you need to, as we always recommend to our clients, you need to consult your tax uh, preparer or your tax consultant or your lawyer if you have specific issues that you think you need to run by them. All right, we are going to talk about two things today. And first up is the Virginia expanded paid sick leave. That is one of two laws that was signed earlier this year by the governor. And again, this is paid sick leave. We're going to run through this probably fairly quickly. And then the bigger law that we're dealing with, we're going to talk about second. So here we go with the expanded paid sick leave. All right, so there is a new leave law in town, and actually in the state. And this law is going to significantly expand paid sick leave protections in Virginia. Now, you all may not even have been aware that during COVID, the state actually did pass a leave law for home health workers where they would receive 5 days of sick leave during the COVID era, and actually that law is still effective. You remember a lot of people began using telehealth and having home workers coming into their homes rather than going to doctor offices during the pandemic. And so they decided to grant those home health workers some leave. And this just kind of takes that law and expands on it. So that was a really narrow law at that time. Now, having said that, okay, what does that mean to you? Well, right now, you're really on your own as an employer in Virginia to, number one, decide if you're even going to have sick leave and vacation leave, and also how are you going to structure it. Well, once this law is effective, nearly all employees who work in Virginia are going to be entitled to sick leave, and it's going to be phased in. And the home health workers that were covered by the earlier law, believe it or not, are excluded from this law. Well, I guess not, believe it or not. That makes sense because they already have their own sick leave. But the benefits are going to be phased in for employees of private employers as of July the 1st of 2027, if you have 50 or more employees, so anyone who's on this call with 50 or more employees are going to be affected by this law in a little bit less than a year, right? 7/1/27. Then January 1st of 28, that goes down to employers with 25 or more employees. And then as of January 1st of 2029, it's going to apply to employers of all sizes. So that means that pretty much all employers and all employees of private companies are going to be affected by this leave. This is going to include your full and part-time employees, and it's also going to include any temporary employees. Now that means your W-2 temps as opposed to temps that come through an agency. The agency is going to be responsible for agency employees. So how does the sick leave accrue? How do people earn that sick leave? Here's the way it's going to work. For every 30 hours that an employee works, they need to receive 1 hour of paid sick leave. So you can tell right off the bat that you're going to have to do some record keeping. Hopefully, a lot of this is going to flow through your payroll. And you're going to see a little bit later, we're going to talk about what you need to be doing. And talking to your payroll provider is probably one of those things. Now, remember, the benefit starts July 1st of 2027 if you have 50 or more employees. So you have a little time. It's not an emergency at this moment. But everything today, you're going to be thinking about as we go along, hopefully, and preparing. So if you have exempt employees, that's employees who are exempt from overtime pay. Those people are assumed to work 40 hours a week unless their normal work week requires a different number of hours. I've known exempt positions that had the employees worked a regular week of 44 hours. So in any case, exempt employees are assumed to work 40 hours a week unless you plug in some different number. And the sick leave accrual begins immediately. And by that, it means when you hire someone, sick leave begins accruing immediately. Now, there is a maximum. So the maximum that employees are entitled to under this law is 40 hours of sick leave. So that means that as the year goes along, the employee doesn't use any of this leave, let us just say, then that employee at some point, I think it's at the 1,200 hour mark, 1,200 hours worked, that employee will have that full 40 hours on the books, and then they stop accruing. So it's a 40-hour benefit. You may already have that amount of leave. You may have more than that. And this law certainly does not tell you that you can't have more than that, because in everything I say today that has a maximum, just be aware that the employer can almost always do more than the law requires. So you don't have to diminish your sick leave benefit in any way. Second interesting feature of this law is that there is a carryover feature. So at the end of the year, whatever your employee has on the books under this sick leave law, they will carry that over into the next year. And again, let's just say they have 22 hours left at the end of the first year. January, February, March, et cetera, of the following year, they're just going to keep accruing and adding to that 22 hours until they get up to 40. And if they don't use any, then that 40 hours again, it just sits there. It doesn't go anywhere until they use some of it. Now, that also does not mean that you're going to have to pay out this leave when employees leave, because you're not. It is not a vested benefit, and it does not have to be paid out to employees who leave the company. Yeah, we're going to talk about in a minute that there is a restoration of leave for people who leave and come back. But we're going to talk about that in just a minute. Now, how can the employees use this leave? And you're going to see a departure from what we're used to thinking about when it comes to sick leave. And as we go down this list, you can probably see that right away on this slide. So the employee can use this for preventive care. They can use it for medical care for physical or mental illness or injury, which you would expect. They can use it to care for a family member with a health condition. Now, for many people, this is a departure. I remember probably for the bulk of my full-time career, many companies had the rule that sick leave could only be used for the employee's own sickness. Well, in this case, with this new law, you can use it to care for family members. And then here's the biggie, something called safe leave. I've noticed this trend over the past couple of years as more states add these laws to their books, more are including something called safe leave. And you can figure that out, or you can see on the slide what that means. And again, this applies to employees and family members. And it includes situations where you may be addressing a domestic violence situation, sexual assault, stalking, that sort of thing. Your employees are able to use this leave to help them out during these situations, such as if they need to seek medical care, if they need to seek legal services or counseling, or maybe relocation. Maybe they need to leave an abuser and find a different place to live. So all of this, we're all going to have to get used to this because these are the new rules pertaining to that 40 hours of leave. Now, this is going to be interesting to see as we go along with these laws, because if you already have a more generous benefit than that, let's say people in your company get 80 hours of sick leave a year. You don't have to apply this to all 80 hours. You can segregate this 40 hours from the other 40 hours and have different rules for both of those. So we're going to, at some point, get some more practical information about that, I hope. All right, now here's another departure in terms of what we're accustomed to when it comes to leave time, even FMLA. This is a departure from FMLA. The definitions and the family members covered. So first is it covers a child of yours, and that's quite a list of the qualifiers of your biological child, adopted child, foster, stepchild, legal ward, or a child to whom the employee stands in loco parentis. That is simply a fancy Latin term for a person who stands in place of the parent. So I'll just give you a personal example of that. Many years ago, when my mother was a foster parent, we had a friend who was in the Navy, and he was a widower, and he had a small child, and he had to go out to sea at one point. And so outside of the foster system, he asked my mother if she, and actually my mother offered to take this child, bless her heart, her name was Michelle, and she was just a lovely little girl, and she stayed with my mother. And so in that circumstance, my mom would have been able to use this sick leave to care for her because she was standing in place of the parent. All right, so it also covers your parents. And again, the same list of qualifiers. It covers a spouse or domestic partner. Now, a lot of times here in Virginia, we don't think a lot about domestic partners because they are not, domestic partnership is not really recognized in Virginia, but under this law, you will be able to use a spouse or domestic partner. Use the leave for either one of those. You'll be able to use it for a grandparent, a grandchild, or a brother or sister. Now, here's where it gets into very interesting territory. You can also use it to care for individuals for whom the employee provides or arranges health or safety related care. So some person who falls under the care of your employee um, would be able to use the sick leave in order to arrange health or safety related care for that person. And then finally, any other individual related by blood or what they call affinity, whose close association with an employee is the equivalent of a family relationship. So my thoughts immediately went to somebody who's particularly close to an aunt or an uncle or something like that. Of course, that's a family relationship. But anyone that you are in a sort of family relationship with, you would be able, or your employee would be able to use this leave to care for those people. Now, this leave is certainly not transferable from one employer to another, but this leave would be protected if your employee is transferred to another division within your company. Also, if you have a merger or an acquisition and a successor company moves in, then that company would be responsible for continuing this, whatever balance the employee has, and continue the accrual just like you were doing. In addition, as I mentioned a minute ago, former employees who are rehired within 12 months, you need to reinstate whatever their balance was when they left. So just keep that in mind. And again, over the next 11 months or so, we're going to hear a lot more about this, but hopefully you'll find this slide presentation to be a resource for you as we go along. One thing I know, sometimes my slide presentations tend to be wordy, I have heard, but I do like for people to be able to read back and remember, oh yeah, I remember seeing that, as opposed to trying to figure out, oh, what did she say about that? So hopefully you use these slides as resources. Now, as you might imagine, there are penalties for non-compliance. So on the left side, I've got employee complaints. So the employee may file a complaint with the Virginia Commissioner of Labor and Industry. And if you are found in violation, then you may receive a financial penalty from the state. Then on top of that, you've also got employee lawsuits. An employee can go to a lawyer and say, I would like to talk to you about how my employer treated me. And in that case, if it's a worthy complaint, then the loss in court could result in you, the employer, paying for the benefits. It could involve payment of lost wages, employee attorney fees, and that sort of thing. So you really want to do your best to comply with this law. Now, here is an important notice. You may substitute, as I sort of mentioned a minute ago, you may substitute your current plan. You may use that current plan to fill in this 40 hours, as long as these two things are true. You must allow leave for the same purposes, and it just flat out has to meet the law's minimum requirements. And you have to basically update your policy. So I have had a couple of people, or I've heard a couple of people or employers say things like, oh, well, we already have sick leave. And that's great that you already have it, because that means a slightly less burden for you. But you still have to bring that current plan, at least 40 hours of it, into compliance in order to be able to substitute your current plan for the new plan. So I hope that makes sense, that it must comply in every way with the requirements of the state for this particular law. All right, now the Virginia Expanded Paid Sick Leave Law, here are some recommended actions for you to be thinking about right now, maybe even starting to work on. One thing, become familiar with the new law so that you understand the basics. So there's lots of information out there about it. Law firm blogs are a good source. We're trying to get information out, and we'll do a podcast episode or one or more. With this webinar, we have newsletter items. So we're going to try to keep you up to date as we go along. Now, companies with existing PTO and sick leave, you're going to want to review and revise your existing PTO/sick leave policy so that at least 40 hours of it conforms to the law. Excuse me, I have to keep stopping and taking a drink now and then. Now, companies with no current PTO or sick leave, you got to create a policy that conforms to the new law. And I know for small companies that don't currently have sick leave, this is going to be more painful than for those who are just updating a policy. And we recognize that. Start looking at your handbook and where you've got your benefits section and your rules about how they can use the sick leave and that sort of thing. Start looking at those things and rewording, or it's okay to wait a little while, because there will be guidance coming out. I'm sure you may even have model updates for handbooks, and I'm certainly going to keep my eyes and ears open, and will be communicating with our employers on a regular basis as I find out things, or a model policy and that sort of thing. I will share those with you. Also, as I mentioned earlier, prepare your payroll and tracking systems before July 1st of 2027, particularly if you have 50 or more employees, and talking with your payroll provider. Payroll providers can be an absolutely amazing source of help and information on stuff like this. So I hope that you all have a good relationship with your payroll provider, and that they, like I say, they're very up, especially if it's a national company, on laws, and can just be a good resource for you. What to expect. The Virginia Department of Labor and Industry will release additional administrative guidance and rulemaking and a mandatory workplace poster. So yeah, you get a new poster to display. One of these days, maybe we're going to run out of wall space to have all these posters. But for now, you're going to have to add this one to it. And again, before the laws face effective dates that start in 2027. The DOLI will also adopt regulations to clarify record keeping systems because, again, you are going to need some record keeping systems. Establish confidentiality standards for employee health or domestic violence information. That's a new dimension now of your HR record keeping, that you may have private information about domestic violence that you haven't had before, and to provide guidance on required notices to employees. So, surely there will be notices that we're all going to be required to deliver to our employees. And once again, I'm sure there will be model notices at some point that will be published. So don't panic. We've got time. Okay. Now, the sick leave that we just talked about was kind of today's opening act. The next thing we're going to talk about is kind of like the main event. And just so you know this, you see it says coming in 2028. I want to make sure you know why are we doing this right now? That's a long time away. Well, I have two reasons for wanting to share this information with you now. One of those reasons is because there may be people on this webinar right this minute who have never heard of any of this. And so I want to get the word out there that this is coming and that it's going to be phased in, et cetera. But the second reason that I want to get this out here now is because if there's anyone on this webinar right now that is not familiar with internet, YouTube articles and the people commenting on those articles, I've seen much really bad information in those comments. People who believe this or believe that about this law. And just in case anyone on the webinar has heard stuff, it may or may not be true. Just because you read it on the internet does not make it true. And so I want to give you a basis in fact so that you know what the facts are and don't have to be in a position of thinking, oh my gosh, that can't be true. So Virginia Paid Family and Medical Leave Insurance is technically what it's called. And this is the biggie. This one is going to have a very interesting effect on employers in our state. So it is called Virginia Paid Family and Medical Leave Insurance, but the insurance is not exactly insurance the way we traditionally think of it. And what I just did there was jump down to that last box. It's not insurance in a traditional sense. You don't pay premiums somewhere and then you have to file claims as an employer. This is going to be funded by contributions from employers and employees that are going to be based on payroll. Now, I'm not going to hazard a guess as to what the percentage is going to be, but I can tell you that I think 12 or 13 states already have plans like this in place. And generally speaking, the percentage of payroll runs about 0.75%, so 0.75 to 1% of payroll. And in Virginia, that's going to be split 50-50 between the employer and the employee in most situations. And so we're going to cover that in more detail in a minute. So that means, yes, you as an employer, through what amounts to a payroll tax, will be paying a percentage of your payroll into a fund that's going to be administered by the Virginia Employment Commission. All right, so now I'm going to beam myself back up to the beginning of that slide, where it talks about a little more detail about how this thing works. So Virginia's new paid family medical leave insurance, which I'm going to call PFMLI henceforth, that program is a statewide, state-administered employee benefit. It was enacted in April of 2026, and it provides job-protected leave for qualifying events paid at up to 80% of employee pay. Okay, so employees may be able to be paid 80% of their pay while they're on approved leave. PFMLI is designed to give employees financial stability and job security when they need to take leave for significant life events while providing employers with a standardized statewide paid leave framework. So this means that as an employer, all of this means that you all, unlike FMLA right now, if you're an FMLA employer, you do all that administration. When it comes to this new benefit, all of this is handled through the Virginia Employment Commission of Virginia. So you pay your monthly contribution into the state. The employees are going to apply directly to the state. Obviously, you're involved because you're the employer, and they have to go through you to, let you know they need the time off. But then they go through the Virginia Employment Commission to apply for the paid benefits. You don't have to worry about, how much they're going to get paid or any of that sort of thing. That's all going to be handled through the state. It is not related to unemployment compensation, but it does work in a similar way that, if you have a former employee that goes out on unemployment, you don't have to worry. All you got to do is fill out a form, and then the employee deals directly with the VEC. So it'll be the same with this leave plan. For the money aspect, it'll be all going through the Virginia Employment Commission. All right, so now what's the timeline on this law? The timeline on this law is set out right here. So on October 1st, and I'll be honest with you, I'm not sure that it is actually on the 1st, but October of 2027, that's when the government, the VEC, I believe, is going to release the amount of the contribution rate. So you remember a few minutes ago, I mentioned the 0.75 and the 1%. That's the time frame when we're all going to know what that rate is going to be. So we look forward anxiously to that. Obviously, we have a year and months to go before that announcement will be made. Then what happens next is beginning April 1st of 2028, that's when you begin withholding payroll contributions, and that's when you begin, calculating your contribution, and then you will begin remitting those funds to the VEC on or around April 1st of 2028. Then December 1st of 2028, that's when the actual benefits launch. So that means that your employees that are eligible can begin applying for and receiving paid benefits for their qualifying events. All right, so I thought I would take a minute here. And again, I realize if you're a small employer, you don't have, if you're under 50, you don't have an FMLA obligation, so you may not be very aware of what's in the left-hand column. But for those of you who do have more than 50 on this webinar and do have to be concerned about FMLA, I thought I would just kind of spell out a comparison between these two benefits. Okay, so first of all, FMLA on the top line, it is unpaid job protected leave up to 12 weeks. With the Virginia PFMLI, they get paid 80% of the employee's average weekly wage up to 12 weeks. And I think I may cover this later in the slide presentation, but what would happen would be if you are subject to FMLA, you would have FMLA and this Virginia paid leave run concurrently. So as soon as the person says, oh, I'm going to have a baby, I need to take FMLA, that's when the wheels start turning toward, as soon as they go out, FMLA kicks in and the Virginia PFMLI hopefully kicks in. So just be aware of that. That would be concurrent, not one following another. Now, that is assuming that the person is taking leave for an event that is covered by FMLA. The PFMLI is a little bit broader, so you may have situations where they may be taking leave that's not covered by FMLA. And if it's not, then you're not going to ding their FMLA balance if it's not an FMLA covered event. And I apologize. I know I'm throwing so much information out there. And as the months and even the years go by, all of this is going to be repeated in a lot of different places. And so you will become more familiar with it as time goes on. All right, under FMLA, employers with 50 or more employees are affected. Under PFMLI, just about all employers will participate in this plan. Now, under FMLA, the reasons for leave are fairly narrow. Your own health condition, family care and bonding, and then a couple of different types of diverse military needs. Under the new law, the reasons for leave, again, are going to be your own health, your family care and bonding, the military needs, and then employee and family safety needs. Now, I hate to get too deep into the weeds here, but I just want to throw one thing out. The military needs, one thing that FMLA is going to continue offering that PFMLI does not offer is 26 caregiving weeks for military members who have been injured or ill and they need a family member to take care of them for 26 weeks. Virginia PFMLI does not offer that as one of the military needs. All right, and then your employee and your safety needs. Remember those safety needs? We heard about those a few minutes ago. Now, when we come to family members, you can see that the PFMLI family member box is way bigger than the FMLA box. FMLA, very simple, spouse, parent, child. The PFMLI, spouse or domestic partner, child, parent, sibling, grandchild, grandparent. Also, similar to that sick leave provision, it includes any individual who depends on the employee for care and regularly resides in the employee's home. So again, let's talk about the aunt that has been like a mom to you, and so she lives with you and you take care of her. Well, you would be able to use her illness as an event under the Virginia PFMLI, which of course you cannot do right now with FMLA. All right, FMLA, you know that there are some hoops that the employee has to get through in order to be eligible. They have to work for their covered employer for at least 12 months. They have to have worked at least 1,250 hours in the last 12 months. They have to work at a site with 50 or more employees within 75 miles. For Virginia PFMLI, the eligibility is based on employee earnings. Now, once again, this is similar to how unemployment compensation works. So it's not based on their tenure or their hours worked. It is based on their earnings. And all this is administered through the VEC, so you do not have to track all this stuff. The earnings formula incorporates multiple calendar quarters, and it mirrors the eligibility framework for unemployment. And again, you do not really have to worry about that. Also, an interesting benefit that self-employed individuals can opt in and they can pay their contribution rate and they can be part of this plan as well. All right, for FMLA, what is the funding mechanism? Well, that was a trick question because there is no funding mechanism because it's unpaid. The PFMLI, as I've talked about, is funded through payroll contributions, and that funds the quote insurance portion of the PFMLI. I do apologize if I'm talking fast. Every time I review this presentation, I think, wow, this is a lot of information. All right, so now this is just kind of throwing some things out there to think about or issues that you may encounter. How do you coordinate all those multiple leave benefits? Like, what if you have the Virginia PFMLI, which you will if you're an employer in Virginia? What if you have short-term disability insurance? And then how does Virginia enhanced sick leave come into play? And then what about employer provided or sponsored PTO? Well, you're going to have to kind of work that out as you go along. Now, I am throwing out an assumption here. I'm going to assume that PFMLI is going to be the first in line. And then you remember it's 80%. And then that additional 20% may be subject to coverage by one of these other or more than one of these other leave benefits. So we'll figure all that out more as we go along, but I don't think it's going to be all that difficult. It's just, you're just going to have a lot to choose from. Now, another question is, what do you do when the requirements of FMLA are different and the employee is entitled to both? For example, PFMLI provides a broader definition of family member than FMLA. So which one do you use? Well, usually the answer to that, probably always, is going to be whatever is the most generous benefit to the employee, that's the one they get to use. Okay, so if you're eligible for FMLA and PFMLI, both, then you're going to get whichever one of those offers the more generous benefit. All right. What are your mandatory employee communications? Not what are they going to look like, but what right now do we know about what you have to do? Well, first, you have to provide a written notice about this benefit and the employee's rights under this law at the time they're hired, once a year, and then as soon as you know that an employee is requesting leave or when you become aware of their intent to take leave, we have to remember that sometimes employees, even under FMLA, can need leave, but they're not in a position to ask for it. So, if, like, they have an accident on Sunday afternoon, and now they're in the hospital, they can't communicate with you, but you become aware because a family member calls you or a coworker says, "Oh, she was in an accident." Then you would be the one to begin to try to figure out how to get these benefits, help your employees get these benefits because you know about it, and so you need to give them the communication even if they haven't officially asked for it. All right, I'm going to do a little Q&A here. We've covered some of this, I think. Which employers are covered? Well, that's going to be nearly all private sector employers, as we talked about. What are the contribution requirements? Now, this is something we haven't talked about. If the employer has over 10 employees, then this quote premium amount or this contribution amount is a percentage of payroll that's normally going to be split 50-50 between the employer and the employee, and that's all done via payroll deduction from the employee side. The employer must remit both the employer and the collected employee portions to the state. Now, if you have 10 or fewer employees, then you as the employer are going to be exempt from paying the employer share. However, your employees must still pay through payroll their employee contribution. Okay, so if you have 10 or fewer employees, you as the employer don't have to pay the share, but your employees do have to pay their share. And note that in either case, the employer is allowed to pay all or part of the required employee portion in addition to the employer portion. Remember, I said a few minutes ago that the employer can always be more generous than the law requires. When do contributions start? April 1st of 2028. And then we've talked about notice obligations. You must provide the written notice to employee upon a hire and annually, and then when the employee needs PFMLI. Now, here's a question. Can I use a private plan? Now, the answer to that is yes, you can. But just like the enhanced sick leave, your private plan is going to have to look exactly like the state plan. And really, if I think through this logically, that tells me that in reality, for most medium and small employers, that's probably just not going to be practical to underwrite this kind of risky plan, and then you're going to have to pay the employee the 80% out of your pocket, basically. But yeah, it can be done, and there will be probably some large employers who figure out that it's going to be to their benefit to run their own plan, and then they would have to get that approved by the state. But yeah, so technically the answer is yes, but probably won't be used very often with just regular average sized employers. Now, what if I already offer paid leave? Well, if you already offer paid leave, then existing policies probably need to be updated to match the statutory requirements. This is if you're going to um, do your own plan, and that includes the job protection, reinstatement, anti-retaliation, and that sort of thing. So there is a hurdle that you're going to have to get over if you want to do your own plan. All right, what is the maximum benefit? We talked about this, 80% of wages, capped at 100% of the statewide average weekly wage. That's called the AWW. Right now in Virginia, the average weekly wage is $1,507.01. And that's likely going to increase by the commencement of benefit payments as of 12/1 of 2028. So if you have a very highly paid employee whose 80% benefit would exceed that $1,500 a week, they're not going to get any more than that. They're just going to get the 1507, even though that's not going to bring them up to 80% of their wages. All right, what should employers do to prepare? Once again, read up on the bill, good sources of info, the Virginia Employment Commission homepage. Eventually, that's going to have a dedicated PFMLI page, law firm blogs, Be on the lookout for Towne Benefits webinars, newsletter articles, and HR on my podcast episodes. Feel free to check in with your payroll provider. And it may be too soon to do that, or you may think it's too soon, which is fine, because again, you're not going to have to really take any action until April of 2028. But at some point, you're probably going to want to talk to your payroll provider about how this, how or do they have a part in all this? Your policy development. Start thinking about the new policy and employee communications that you'll need, and how you're going to change your handbook. And again, model policies are likely to be released at some point. And then just keep up with that timeline. Put something on your calendar for each one of those dates, and just make sure that you don't wait till the last minute, would be my advice, in order to start working on it, because you might have a zillion questions that come up between now and April of 2028, which I'm sorry to say is going to be here before we know it. All right, so what to expect now during the run-up to PFMLI? The Virginia Employment Commission is going to release more comprehensive rules, regulations, and guidance detailing the administrative requirements for employers before the PFMLI rollout. So just be aware of that you may be hearing from the Virginia Employment Commission about all this. Just a little summary about comparing the first Leave Act, which is the paid sick leave, to the PFMLI. And that would be that the sick leave itself is moderate complexity. I mean, honestly, it's probably low to moderate. Your existing leave policy can be modified to satisfy the new sick leave requirements. If you don't have a sick leave policy, then that's going to be a little more complicated to have to implement one. PFMLI, that is going to be pretty highly complex initially, and learning the rules is going to be, oh, wait a minute, can this employee take this leave? Oh, do they also get FMLA? How do they work together? That sort of thing that's going to come up. And unfortunately for employers, probably none of this stuff comes up that often, especially for smaller employers. And so you have to relearn, probably in between everybody taking FMLA or PFMLI, that you have to become reacquainted with the rules. So I would call that a fairly high on the complexity scale. Who administers the sick leave plan? Well, you do. It's your plan. You administer it. You pay the employees on sick leave. You keep the records and all that sort of thing. So that's all on the employer. Under PFMLI, the state administers the actual plan when it comes to the payment, the approval process, and the payment. You, of course, are going to have a responsibility as far as record keeping for your employees, the absence dates and that sort of thing, and approving the absence, which is going to be pretty much a slam dunk. If the state approves it, you're going to approve it. The pay, the employer for the sick leave pays the sick leave benefit. The state pays the PFMLI benefit through the state fund. Timing, benefits begin July 21st for the first round of employers, July 21st of 2027. Did I say that? The PFMLI, the benefit payments are going to start December 1st of 2028. Non-compliance risks are the same, civil penalties and lawsuits in either case. So you don't, you want to make sure you've got your ducks in a row and that you are well prepared for both of these laws. All right, this is kind of my final analysis. Expanded paid sick leave for most employers is probably going to be more like a policy rewrite to bring your policy into compliance with the law. The paid family medical leave is a milestone. It's a milestone moment in employee leave programs. So it is going to be more complex. I don't want to make it more scary than it really is, because numerous states have very successfully implemented very similar plans. Virginia did not completely reinvent the wheel. Virginia has done a lot of what the other states have done, and they tweak things as they go along, but you do have to do some work in getting prepared and having everything ready by the time these things are active. And so that is the end of our formal presentation, but I have 9 questions in the box, and let me see if I can get those. And again, if I can't answer them, I will do a written answer and distribute those to you all. All right. So I have one employer that says we don't have sick leave, just PTO to be used as needed for sick and personal time. Do I need to implement a separate sick leave benefit? Interesting that this question should come up because when I'm trying to fall asleep at night and counting sheep doesn't work, I start thinking about this law, and that is actually the scenario that popped into my head one night. Okay, if you have PTO, that generally means your employees can use that for anything that, for vacation and sick leave, right? And so I don't want to overcomplicate this, but first of all, if at least 40 hours of that is dedicated sick leave, which it probably isn't, or if you can carve out 40 hours of that and dedicate it as sick leave, and then have the remainder as PTO that can be used for any purpose, that might be one way to solve it. And I realize that that's complicated. Um, or another thought would be that just turn your whole PTO policy, make it consistent with the sick leave benefit, and just allow people to use it as vacation as well, but make sure that they can have the 40 hours dedicated to using it for those specific reasons. So that is going to be a tough question to answer. I think we're going to have to get in there and just see kind of how the whole thing unfolds. Or there may be other ideas that people are going to come up with to keep from having to add an additional 40 hours of sick leave, but at the same time, keep the integrity of their PTO plan in place as much as they can. So I'm really sorry that's sort of a non-answer, but that's the best I can see at the moment, is to just kind of try to think through it and figure out what works best for your company. All righty, let's see. Yes, someone has asked, can we get copies of the slides? And the answer to that is yes. I will send the slides and the recording. And if I answer any questions I'm going to say on paper, you know what I mean, then I will send those as well. Okay, so, what happens to the contributions paid into the PFMLI if an employee never uses it? Does the employer and employee get that money back? And the answer to that is no. And here's why. And I think that's one reason why they're calling it insurance. Kind of like if you think through it like your auto insurance, you might get some type of little rebate because you have low usage or your premiums may go down or something like that. But that's the purpose of insurance, is everybody's contribution goes in and stays there, and then everybody gets to use the dollars. And so once they're in the plan, they're there to stay, to be used by later people that come along that need it. And so you could argue, well, gosh, is that fair? And it's like, well, that's the way insurance has to work. Otherwise, the money just won't be there to fund the thing. All right, then I have a question. Does the employee have to contribute to this as well? I think I've answered that along the way. And so the answer to that is yes, this is both employer and employee contributed. And remember that the state is going to announce the total percentage that is going to be required, and then it's going to be split 50-50 between the employer and the employee, except if you have 10 or fewer employees. And then if you're that small an employer, you do not pay any employer contribution, but your employee still pays their contribution, employees. All right, let's see where I am in my list. Oh, now here's an interesting question. Does it cover the children or parents of domestic partners? Wow, that is a very good question. I I would say that for the children, if you are the second parent in the household, you and a domestic partner are the in loco parentis parents for the children, then the answer to that would be yes. I would think. Now, I hope if I'm wrong about that, I apologize, but to me, that would seem to fit the definition of in loco parentis, and those children are covered um, by the law. As far as parents of domestic partners, I would say probably not, because in-laws are not covered by the law. So I don't believe that parents of either your um, legal partner or a domestic partner would be covered. And again, I'm sure there'll be more clarification on this, but my instincts kind of tell me that that's the way that would fall out. Um, yeah, good question. How does the employer verify that the employee is using the sick leave for those specific reasons? Do they need to provide some sort of proof? And my answer to that would be, when you right now, you should have a policy that pertains to your sick leave policy and what the parameters are for using sick leave. Um, so you would rewrite your policy to include all those reasons as reasons for using it. And the question now would be, what do you require now for your employee to use sick leave? Now, generally speaking, if they're using vacation time, that there's no proof of anything required. That's vacation time. Sick leave, if you want doctor's note, medical certification, then you could probably apply the same standard. Um, I'm thinking through how rigid and how strict they're going to be. Sometimes employers have a policy that says if you're going to be gone for less than 3 days, then we don't need a doctor's note. If it's going to be more than 3 days, so you may be able to apply that same standard. But if it comes to requiring something like, for example, a question came up between me and someone I was talking to the other day about documenting, let's just say, um, that the relationship of a domestic partner. That for one thing, you don't want to be discriminatory in how you ask what you ask for from employees. You want to treat people consistently. And generally, I think it's going to be, for many cases, other than some type of medical event that's going to keep them out for multiple days, some type of written attestation from the employee that I'm going to take this leave this date for this person who is my whatever the uh, category is. I know that I can imagine, I don't know this, but I can imagine that the state is not going to look favorably on setting too high a bar, like causing somebody to have to go to an expense to get some type of documentation for something. But again, we'll have to see how that. Unfortunately, sometimes these things get played out in court. But that would be my inclination, is to say that some type of written attestation of why they're taking this, unless it's a medical thing. Like right now, you already require, a return to work certification by the doctor that you're well enough to be there, or a doctor's note as to why you needed to be out for a week, or your child needed you to be there for a week or something like that. Okay, let's see. Okay, so carryover question. Right now, we follow all these rules, except we cap the carryover at 24 hours. So they would have the following year is 64. No, you don't need to add anything to it. If the and I'm sorry, maybe I'm misunderstanding what the question is. Under this, under these 40 hours that you're required to offer, 40 is the maximum that you have to allow them to have on the books. So once they're up to 40, like for example, December 31st, you have an employee who's been there all year, let's just say. They have 40 hours on the books on December 31st. First payroll in January, they're not going to accrue any more leave because they've got their full 40 hours. Now, if you have additional sick leave, I don't know if payroll can segregate. This is Virginia paid sick leave requirement bucket, and this is our other 2-week sick leave benefit bucket, and they can continue accruing as you normally do in your other sick leave bucket, but you stop accruing in your required 40-hour bucket. And I hope that makes sense what I'm saying there. That may be necessary to do that. And all these questions are really outstanding because this is the type of practical stuff that you're going to have to think through as we go along to implement this. And it did give me an idea. I might look. Colorado has a particularly good website for their PFML, and I might just look on there and see if they've got any answers to how they handle this. How employers handle this type of thing. Should we have two separate buckets of leave, one for the 40-hour requirement and one for our regular sick leave? Let's see. Okay, let's see. Does anyone know if this includes agriculture businesses? I'm assuming by the language in the law that no business is automatically excluded, that if you have temporary employees, if you have seasonal employees, if you have part-time employees, all of those people are going to be eligible to earn this sick leave as far as I know. And this is of private employers, not the government, not the military, but private employers, which is most of us that we deal with. So I would right now count on all of your employees having to be in there. And as we go along, there may be more clarification. Other people may have an interest in that question too, and they ask that. So I would just say we need to keep our eyes and ears open for all of these questions that pertain to us. All right, let's see. Are high earners considered employees? Okay, now you're getting into territory that's slightly different. Whether or not the person is highly compensated is not what determines if they're an employee. I believe the rule is probably going to be that anyone who gets a W-2 form from your company, it's not going to matter how much they earn. If they're a W-2 employee, they're going to be included in both of these benefits, that both the regular sick leave of 40 hours and the PFMLI. That's the way I understand it at this moment. Now, if they're owners of the company and they don't get a W-2 form, or if they get a, what is it called? I'm sorry, I'm forgetting, K-1? Anyway, that I honestly don't know the answer to that. If they're owners, I don't believe that if they don't get a W-2 form, they will not be eligible for the benefit. Ooh, here's a good question. Are the PFMLI contributions considered pre-tax? I do not believe so. Yeah, I'll need to answer that one offline because I don't want to give you the wrong answer, but somehow I don't know. I don't think they will be because this is a Virginia state program. So I don't think that it could affect your federal income taxes, but I will review all these questions. And if I find out anything different on any of them, I will include it in my answer sheet. Yes, you will get a copy of the slides. I think I answered that. Yeah, I think I'm back around to the beginning of the cycle again. So I think I've answered all of the questions. And I really hope that you all found this of interest and gave you, obviously, you've got some things to think about. I hope that this whole process helps you understand a little bit better if you've heard about this and you're panicky, or you've heard about it and you're like, oh, I didn't know this was going to apply to us. Then like I say, I hope that you've gotten some of your questions answered, and we will know more as we go along. But I really, really appreciate your time and your attention, and I want to emphasize that I get to talk with a lot of you on a regular basis, and I very much appreciate that opportunity. Corbin and I both, I know I'm speaking for both of us when I say we very much enjoy working with our clients and feeling like we're helping out helping you just make your lives a little bit easier in your HR and benefits and compliance world. And so you have our thanks, and we look forward to seeing you in our next webinar. Now, this one is going to be repeated in September. I thought that September might be a good time. We're all back from vacation, hopefully by then, and just some reminders as we go along in 2026 into 2027 that the sick leave comes first, and that just to remind people that if you have questions or haven't done the work that needs to be done, that it gives you an incentive to kind of get started on that. But feel free to sign up for it for a second time, or maybe you've had enough and you're like, okay, we're good to go. I know what I'm doing, which is awesome. So thank you, and I hope you have a lovely rest of your week. Take care. Bye now.